Welcome back to Carolina Journal Radio. I'm Donna Martinez. Now that Governor Roy Cooper's Department of Environmental Quality has ordered Duke Energy to excavate its remaining coal ash sites, the cost of cleanup has risen significantly. And it's leading to all sorts of questions about who will end up paying for this and about Governor Cooper's changing view on that subject. Don Vaart is the senior fellow with the Locke Foundation. He, of course, is a scientist and the former secretary of DEQ during the Pat McCrory administration. Don, welcome back to the show.
Thanks for having me.
All right, coal ash. That is the residue from using coal to produce energy. And our listeners may recall a few years ago, there was a spill of some of this into the Dan River, and that really brought the issue to the forefront. So what has the state now told Duke it must do?
Right. So coal ash presents really two different kinds of problems. One is the one manifested Dan River, which is you've got a structural failure, in that case due to a lack of maintenance by Duke, and that caused the leak into the river. So that's a structural issue. Then the second is simply the potential that groundwater is somehow contaminated by storing the coal ash underground or in the ground. So years ago, under the McCrory administration, the legislature passed the Coal Ash Management Act, and that gave DEQ the authority to tackle this issue. And the act also defined a certain number of coal basins to be dug up, but it left 6 as what they called low risk. And those low risk basins could still have been dug up, or they could be kept in place and capped and drained. But it was up to the department to do that, and the risk was such that the time frame was later. And so this is where we are now. In a sort of an abrupt announcement last year, the department said all 6 of those remaining basins had to be completely excavated, which is the most extreme and most expensive option. Duke had proposed a number of ways of dealing with it, but they were far less expensive, and they included draining most of them and capping them in place. So Duke, of course, was concerned. They have a duty to give us low-cost electricity, and so they filed a lawsuit against DEQ. And that's where it should have progressed. They should have, a judge would hear the two sides, and the science would win out, and whatever came out of that presumably would have happened. Okay, enter in the special interest environmental groups. They, of course, for various reasons, and they're led by their law firm called the Southern Environmental Law Center, they want to just dig everything up. And they're not really all that concerned with the science. It just says that's the best solution, and there's certainly some arguments against that, but that's what they wanted. And so they had filed a lawsuit as an ongoing lawsuit. So what happened then was that there was a settlement, and this settlement resulted in not all the coal ash being excavated, but more importantly, it dealt with who was going to pay.
That brings us to the nut of the question we want to talk about here today. First of all, how expensive is this likely to be, and who is going to pay for this?
Right. So as a result of the excavation that was dictated by the Coal Ash Management Act, which was, as I said, passed under Governor McCrory's administration, the costs were already pegged at about $4 billion. The costs associated with digging the rest of this the remaining coal ash basins would have been $5 to $6 billion more. The settlement, as I said, left about 30% of the coal ash in the ground, and so the estimates I'm seeing is something around the order of $4.5 billion more dollars.
That's pretty much double then.
Absolutely,
right?
Absolutely. But the questions, to me are, well, wait a minute. I thought there are many, but one of them is, well, wait a minute. I thought the department said that the science dictated that everything had to be dug up. And that's not the case. So I didn't understand, what was revealed that maybe the department didn't know about. But probably the most important facet is that the department, which was representing the state of North Carolina, agreed in the settlement to those provisions that will absolutely bring those costs to the customer.
So you and I, who are a Duke Energy customer, when you get your bill, you're going to see, as part of your bill now, these cleanup costs.
You're going to see them as manifested in higher rates. It won't say due to settlement signed by Governor Cooper's administration, but it'll be higher. What's surprising about this is that in 2014, Governor Cooper was very adamant. That time Attorney General Cooper was very adamant that those costs should be borne by the shareholder, not by the customer, and even was pushing for legislation that would prohibit passing these costs on to the customer.
As I recall, there was a number of news stories actually written about that, and,
Oh, yeah.
and really casting then Attorney General Cooper as the protector of the consumer.
No question. And now if you fast forward to the settlement, there's actually language in the settlement where DEQ and the special interest environmental groups say that this excavation is reasonable, prudent, and in the public interest, which is the requirements for passing it along to the customer. In addition, they actually sign on to, in the settlement, that they pledge they will not challenge Duke when they bring this reimbursement to the Public Utilities Commission. They won't challenge that. They won't argue. And this is what's so surprising. I saw an article just recently in the Daily Tar Heel, I believe, where somebody from one of those special interest groups bemoaned the fact that the customer may have to pay for this. Well, his group signed on to the very language that will ensure that will happen. So it was kind of surprising. It was surprising that Cooper did the 180, and it was kind of hypocritical for some of these environmental groups to act like they didn't understand what they signed. And I'm still not sure I understand why the DEQ, after having said the science dictates all the coal ash should be excavated, has now settled for some 30% less than that.
Yeah, so in addition to the big-time question about the change in Roy Cooper's view on who should pay from 2014 when he was AG to now, his Department of Environmental Quality saying, well, yes, the people who get the bills will see that in increased rates. There's the question about the science. So what happens from there if the science really doesn't dictate this type of settlement?
So Duke is trying to Duke wants this settlement to become a court order. That'll solidify their position to make sure the customer pays for it. But there may be customer groups that can challenge that settlement. Right now it's out for public notice. We don't know if that's going to happen. But if someone were to challenge that, you would then potentially see the unfurling of the reasoning behind the settlement in a court context.
And if indeed that happens, we will have you back to talk about what is revealed in any of those documents or those hearings. We're talking with Don Vaart. He is a senior fellow with the John Locke Foundation. By the way, he writes and talks about these issues, as does our Director of Regulatory Studies, John Sanders. And you can find all of that analysis at johnlocke.org and carolinajournal.com. Don, thank you very much for joining us. Appreciate it.
Thank you.